Your medical malpractice case, your accident case, or even your wrongful death case has been going on for 2 long years. And now you're trying to put pressure on your attorney to settle your case. You don't want to have to go to trial. And now you want to go ahead and settle this case and be done with it. Your attorney tells you it is not the right time to negotiate. And now you don't understand. And you ask your attorney and you say, why? And your attorney tells you because the defense is making a motion for summary judgment first. They want to see if they can get your case thrown out before they have to offer a single dime. Would you like to know what this is all about? Come join me for a walk through this beautiful area. You'll have to guess where I'm walking as I share with you the answer to that question. I am Gerry Oginski, a New York medical malpractice and personal injury attorney. All right, so now let's say you brought a medical malpractice case and you believe that your case is worth $5 million, but you haven't heard a peep from the defense in more than 2 years, telling you and your attorney that they are interested in trying to negotiate your case. You can't understand why. You don't know why because you believe that you have the best case ever. You believe that you have the strongest case with the best experts, and you don't understand why your case has not been resolved and settled and put to bed. Your attorney tells you that now all discovery in your case is finished. All the necessary documents that needed to be exchanged with the defense are done, and now comes time for the defense to decide whether they want to try and get your case thrown out before you ever reach trial. And you say, what are you talking about? What does that mean? I'll tell you what it means. It means the defense now has an opportunity to make a motion for summary judgment. And in case you don't know, a motion is a written request to the judge to take action, to do something. And in a motion for summary judgment, it's a formal written request to the judge to throw your case out and never have to get to trial. That's what a motion for summary judgment means. Now, why and how would the defense be permitted and allowed to go ahead and do this? All discovery in your case is finished. Now, technically, you've told the court that your case is ready for trial. But before you ever get to trial, now the defense turns around and says, you know what? We have one last shot at trying to get your case thrown out before we ever have to negotiate. So we're going to do everything possible to go ahead and show that our experts believe that there is no valid basis for a case, and we're going to put in all of our proof and all of our evidence, and we're going to show that as a matter of law, you, Oginski, and your client don't have a valid basis for a case. And importantly, that there are no material questions of fact that need to be answered by a jury. In that instance, now, when they go ahead and make this formal written request, it is as if they're having a trial. But the trial is being done on papers. So now they're going to spend hundreds of hours of their time putting together all the papers that they believe is appropriate for the judge to evaluate. And now, in response, we have to go ahead and actually oppose all of their papers. And now we have to put in opposition papers. We have to gather our medical experts. We have to gather our evidence and testimony, and now put them in to show to the judge that there are material questions of fact that have to be answered by a jury. Now, you should know something very important. This motion, this written request to try and get your case dismissed, is not an opportunity. The defense is not asking the judge to decide who is wrong, who is right, who is more likely right than wrong. That's not what happens with these requests. Instead, the judge has to decide whether there are issues of law to be decided. The judge has to determine whether there are questions of fact to be decided. Now the judge will have no choice but to deny the defense's request to throw your case out, and your case will go to trial. If, however, the medical experts are clear-cut and there are no disputed facts to be resolved by a jury, because that's what the jury does in these types of civil cases, they evaluate questions of fact, then the judge will be well within their right to say, no, there are no questions of fact, only issues of law, and I determine that this case should be dismissed. In that instance, the defense will never offer a dime. Why? Because your case will be dismissed, and they will never have to go to trial and never run the risk of having a jury come back with a verdict in excess of what they believe your injuries are really worth. In that instance, now your case is done and finished, and the only option you will have is either to ask the court to reconsider their decision or go ahead and appeal that decision. Once the defense submits this formal written request to the court, to throw your case out. Now I will have to go ahead and prepare opposition, which will literally take months to do, and then it will be a few months before the court renders a decision. So don't think for a second that just because you have now finished discovery, that means your case is going to go forward to trial. The defense, in all likelihood, is going to do everything possible to get your case thrown out before they ever have to negotiate and offer a dime. So why do I share this quick information with you? I share it with you because I understand you're frustrated. Your case has been going on for a long time, and I recognize and I understand that you believe strongly that you have a valid and meritorious case. Your experts believe likewise. But that does not automatically mean the defense is going to start negotiating. Not at this point. Only after they have exhausted every opportunity to get your case thrown out. Only then, once they are faced with the reality of having to go to trial, now they may start to engage in settlement discussions. And one final point, just because you believe your case may be worth $5 million and you have a great case, doesn't mean that the defense sees it the same way. The defense may weigh the risks of going to trial and say, okay, we recognize we have some exposure, some liability here, but we don't think in your wildest dreams that your case is really worth $5 million. Maybe, they argue, maybe it's worth $1 million, maybe $1.5 million, but they will always dispute the extent of your damages. And that will be a long, hard fight. And if they cannot agree, if you and your attorneys cannot agree with the defense as to the true value of your injuries, then a jury will have to decide those questions. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're watching this video because you wanted to see the beautiful scenery. Try and tell me in the comments where you think I'm shooting today's video. And as always, if your matter happened in the state of New York, but you have not yet started a lawsuit and are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.